welcome and enjoy the course. It's being taught by one of our great friends at IICLE. Mary Foster is a tremendous asset to all of our programs. She's been a great friend to IICLE over many years. We've been so fortunate to have her help us develop this whole Tales from the Media course, which she designed last year, and now we're reinventing it to involve some of the more Illinois-specific cases. As you probably understand, there are Illinois-specific cases that may be of some interest. Mary's a professor of legal ethics at Northwestern University School of Law. She also has taught at the DePaul University College. She was a senior trial lawyer and litigation manager for the Illinois Attorney Registration and Disciplinary Commission. She's a graduate of the University of Illinois College of Law. Ladies and gentlemen, my good friend, the esteemed Mary K. Foster.
Thank you. As noted, this is the second Tales from the Media program. Last year we talked about the Duke lacrosse case, the Elliot Spitzer matter, and the Alton Logan matter. And today we're going to focus on the ethical issues arising from the media and news reports from this year. And needless to say, it's been a very busy, busy year. Almost on a daily basis, you can open a newspaper or turn on your television and you'll see some news clip where there's a legal ethics issue in the news report. So it's a very timely presentation. We're going to talk about we're going to focus on 5 areas today. First, we're going to talk about our former governor, Rod Blagojevich, and his current indictment. Then we're going to turn to the U of I admissions scandal, or the clout scandal, as it's sometimes called, which really arises out of the Rod Blagojevich matter. And then we'll turn to some of the tax problems that faced some of President Obama's cabinet appointments in his first 100 days of office. We'll then turn around a little bit and look back at the torture memos under the Bush administration. And finally, we'll finish up with what I'm calling "It's the Economy, Stupid." Tales of lawyers who are facing ethical dilemmas and or professional discipline problems in hard economic times. So you'll note that I've included stories that include both Republicans and Democrats. Legal ethics issues tend to cross party lines. So for today, we'll focus less on the parties and the administration's point of views in these stories and focus more on the lawyers that were involved in each of these matters. We'll look at what's happened, what is going to happen, and what's likely to happen in the future with regard to these matters. And while probably most of us have very little desire to ever become governor of the state of Illinois, Treasury Secretary, OLC counsel, or even dean of a law school, I hope that you can take some of the lessons we'll talk about today and translate them into your own practices and into your own lives. Because really these dilemmas are not specific to the government attorneys that were involved in some of these scandals. And the theme of today's presentation could really be called "Where Were the Lawyers?" Because in each of these presentations, there were lawyers present who either let the misconduct happen or who stood by and did very little to stop it. So we'll talk about that issue as we discuss these matters, but also ask yourself, in the context of your own practices, whether you would face any similar dilemmas and how you might react if you did face those dilemmas. We have 4 hours. So we will not be able to go into, for instance, the torture memos in any great detail. We could probably spend 4 days just talking about those memos alone. But we're going to focus simply on some of the ethical issues, the legal ethical issues that the lawyers faced with regard to each of these matters. That being said, we have 4 hours. And while I plan to break up the sound of my nasally, often too high voice with some video clips, it will get pretty boring if I'm the only one talking. So please speak up, offer your thoughts. Please feel free to ask questions. Give us your point of view. We won't judge you today. So please feel free to speak up and keep the discussion going. We're going to turn now to the first matter, and this is one that has dominated the media, certainly in Illinois. And really, it has dominated the national news media, too, thanks to many of the interviews that Rod Blagojevich has done. And we're going to talk a little bit about the indictment of former Governor Rod Blagojevich. Obviously, not all public corruption matters or trials are legal ethics cases. It might just seem that way because so often the players involved are lawyers. Rod Blagojevich is a lawyer. He is there, and there may have been other lawyers that worked for him, and we'll talk about that a little later, who were involved. He is currently on inactive status with the Illinois Attorney Registration and Disciplinary Commission. That means he had a law license. He's decided to go on inactive status voluntarily. Many public officials do that while they're serving in public office so that they don't have to pay the registration fees or do the CLE. They do have to eventually do the CLE if they decide to go back to active status. But I think actually he went on inactive status before he became governor, but it's not clear from the records that the ARDC has. And he could just petition to get his law license back. It's not a major ordeal to get your law license to return to active status when you're on inactive status. If he was to return to active status, the ARDC could do a number of things regarding his law license. They could petition the Illinois Supreme Court pursuant to Supreme Court Rule 774 and ask that he be suspended on an interim basis pending the outcome of his indictment. And that's generally what they do in more serious cases where there is a criminal indictment. But they don't like to interfere too much in the criminal case. So most times the ARDC will not take action against a lawyer until after the conclusion of the federal criminal proceeding. Once a trial has been completed, and for the moment we will assume that a jury finds him guilty, and I do not mean to assume that that is necessarily what will happen, but let's just assume for a moment that a jury does find him guilty. If he's found guilty, a sentencing date will be set. And on that sentencing date, a judgment of conviction would be entered. At that time, then, the commission could move to suspend his law license in the interim under Supreme Court Rule 761 as a result of the conviction. Keep in mind that lawyers do have a duty under Supreme Court Rule 761 to notify the Attorney Registration and Disciplinary Commission whenever they're convicted of a crime. And it provides that it's the duty of an attorney who's convicted in any court of a felony or misdemeanor to notify the Attorney Registration and Disciplinary Commission. Generally what happens then is if the crime involves moral turpitude, and given the charges in the indictment, if he were to be found guilty, that would be considered a crime of moral turpitude. It involves fraud. Then it would be sent to a hearing board, and a hearing board would decide what sanction to impose. Lawyers generally cannot dispute the findings of the jury. In a disciplinary proceeding, proof of the conviction itself is conclusive evidence of guilt. So the ARDC doesn't need to retry the case in that event. For those of you who might know someone who's ever been convicted of a misdemeanor that's a lawyer, in those circumstances, it's referred to an inquiry panel. And then a panel of 3 decides whether, it's 2 lawyers and a non-lawyer, decide whether or not to vote a formal complaint. So not all convictions of misdemeanors result in formal disciplinary action. But certainly there's a process in place for the commission to look at that. The crime does not have to include the practice of law for there to be any ramifications to the attorney's license. So crimes involving a public official rising out of their public duties, the ARDC could still look at that. In fact, 8.4A3, the rules state that a lawyer shall not commit a crime that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. So that's really what the commission and all disciplinary authorities around the country look at when they determine whether a crime should warrant a sanction, a professional sanction.